It is time again for Legal Talk right here on eRadio every Wednesday morning at 10 o'clock, where we unpack legal topics, and we do so with Hahn and Hahn attorneys. Joining us from Hahn and Hahn today is Nirvana Pillay. It's nice to catch up with you again, Nirvana. It's been a while. How are you doing?
It has been quite a while. It's lovely to catch up with you as well.
Yes.
Thanks for welcoming me back.
Yeah, no, nice to have you back. And today, I can't remember what the two of us spoke about last time. Can you remember?
It was about the COVID-19 regulations, the impact that it has on the workplace.
You see, your memory is better than mine. Okay, so today, something different. We're talking about companies and all the stuff that happens before you start a company or during a company, when you're running a company as well, especially if there's just one person who started the company, and what if something goes wrong and all that kind of stuff. So we're asking you a few questions today, Nirvana. I think we'll start off with this one. Can a company enter into agreements before the company has actually been formed?
Well, the answer to that would be yes. So a person acting or purportedly acting on behalf of the company may enter into an agreement for a company to be formed. In terms of Section 21 of the Companies Act, the requirements for a pre-incorporation contract would be the following. So a person may enter into a written agreement in the name of the entity that is contemplated to be incorporated, but does not yet exist at the time. And then the person who enters into the agreement on behalf of the company to be formed is jointly and severally liable with any or other such persons for liabilities created as provided for in the pre-incorporation contract while acting, if the contemplated entity is not subsequently incorporated, or after being incorporated, the company rejects any part of such an agreement or action. And then if after its incorporation, a company enters into the agreement on the same terms, or the agreement is substituted, the liability of a person who enters into the agreement on behalf of the company to be formed in respect of the substitute agreement will be discharged.
Nirvana, how long does the company to be formed have to ratify or reject the agreement entered into by the representative or agent on behalf of the company to be formed?
Well, generally within 3 months after the date on which a company was incorporated, the board of that company may completely, partially, or conditionally ratify or reject any pre-incorporation contract or other action purported to have been made or done in its name. And if within the 3 months after the date on which a company was incorporated, the board has neither ratified nor rejected a particular pre-incorporation contract or other action purported to have been made or done in the name of the company, the agreement will have been regarded as being ratified. So this basically means that the agreement is enforceable against the company as if the company had been party to the agreement when it was made, and the liability of the person who entered into the agreement on behalf of the company will be discharged.
Okay, and what happens if the company rejects the pre-incorporation agreement or action?
Well, in that case, if a company rejects an agreement or action, the person who bears any liability for that rejected agreement or action may assert a claim against the company for any benefit it has received or is entitled to receive in terms of the agreement or action. The person who entered into the pre-incorporation contract on behalf of the company will be jointly and severally personally liable with any other such persons, presumably the company or the directors, to the other contracting party for all liabilities created in terms of that contract, if the company is not subsequently incorporated or after its incorporation rejects any part of the agreement or action.
Can a trust to be formed enter into an agreement?
Well, with this, the short answer is no. Section 6.1 of the Trust Public Control Act provides that a person appointed as a trustee of a trust shall only act in that capacity if authorized in writing by the master. So this means that a person acting in his representative capacity as trustee may only do so upon receiving an issued letter of authorization from the master, and therefore all acts conducted by such person in his or her capacity as trustee of a trust yet to be performed and prior to receiving the issued letter of authorization will be deemed null and void. So such an agreement cannot be resuscitated by subsequent ratification by either the master, the trustees, or the courts.
And Nirvana, is there a solution in urgent cases?
So a tripartite agreement may afford a possible solution in urgent cases where, for instance, you want to purchase a property and you just can't wait until such time as the trust is established. So, for example, an agreement may be entered into between two parties, let's call them Party A and Party B, with a clause in the agreement compelling Party A to enter into the tripartite agreement, in which the sale between Party A and Party B is cancelled, and then Party A is to enter into an agreement with Party C, the trust, once it has been established.
And lastly, our final question for today. What should directors and shareholders do to safeguard the future of the company in the event of the death of the sole director and shareholder?
So in this case, in terms of the Companies Act, a company is a separate legal entity. This means that it can accrue rights and obligations that are separate from the directors and shareholders of the company. It's a juristic person that has directors and shareholders who own it. Thus, the succession of the shareholders should be stipulated clearly. The company, being a legal person, can only act through its directors. So where a director dies, the company becomes incapacitated until such time as a replacement director is appointed. In instances where the director is also the only shareholder, complications will arise should the memorandum of incorporation not specifically provide for the replacement of directors, as there would be no person to immediately make the appointment, as directors are generally appointed by shareholders. This will be the case even in the event that the deceased left a will, if the appointment of the replacement directors are not catered for in the memorandum of incorporation. So it's important that directors who are also the sole shareholders should prepare a will that deals with the following: the appointment of the executor, the distribution of shares, the manner in which replacement directors are appointed. The will established should be in line with the memorandum of incorporation. The memorandum of incorporation of the relevant company should adequately cater for the death of the director and shareholder in a manner that will be suitable for the future of the safety of the company. A succession plan that is clear and thoughtful in order to ensure that the company runs efficiently even after death of the director should be prepared.
Nirvana, and that's it for today. Nice, short and sweet, but it's nice. We get the message, and that's what it's all about. Nirvana Pillay, you're an associate attorney at Hahn & Hahn. Big thank you for your time and your wisdom.
Thank you for having me. I really appreciate it.
Fantastic. Until next time. Thanks, Nirvana.
Thank you. Bye.
Bye.
Are you or your business in trouble and struggling to find a solution? Call Hahn & Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn & Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn & Hahn Attorneys, Wednesday mornings at 10 on eRadio.